Welcome, everybody. Today is Friday, April 11th. Today's topic for our new podcast is the new Deferred Resignation Program recently offered at the Department of Veterans Affairs. My name is Doug Massey. I'm the president of AFGE Local 17, which covers bargaining unit employees at VA Central Office. So to start out, a little bit of background. The Department of Veterans Affairs has about 470,000 employees. And the administration, DOJ, Secretary Collins, they want to cut that workforce by 15%, or about 83,000 jobs. And their claim is that they're going to improve service to veterans, which many of us doubt. The strategy to do this is we've all experienced this. This is about, and you're not going to learn this strategy. They don't teach you this at MBA schools. It's about instilling fear. It's about intimidating employees. It's about demoralizing the workforce so that people leave. And we all know how they're doing that. They're going to have RIFs, reductions in force, the 5 bullet points every Monday, the return to office, which is creating complete chaos. I heard one story where somebody was required to work in a 100 square foot shower stall. And now they have the Deferred Resignation Program round 2 to offer some kind of incentive after people are demoralized where they just want to leave. And there's many people that are already there right now. So what is this Deferred Resignation Program? We saw this back in January, February. I think February 6th, you had to reply. And basically, they advertised full pay, full benefits until September 30th. And that was about 7 or 8 months. The renewed program just came out, and at Department of Veterans Affairs, employees have until April 30th at 5 p.m. to reply. And the same offer, it's until September 30th, full pay, full benefits. You don't have to come to work, administrative leave. So it's about a 5-month severance package. Now, this offer, for some employees, it may be a good offer. For other employees, it may not be a good choice. It's a highly personal decision based on, the number of years you have, your financial situation, how marketable you are to get another job. There's also going to be VERA's coming out, which is the voluntary early resignation authority. But this is one program that's slightly different. And to break this all down, we have a special guest with us today, Michael Fallings. He is a managing partner at Tully Rinckey. They're a nationally recognized labor and employment law firm. They have offices here in Washington, D.C., New York City, California, Texas. And let's bring Michael on. You may have seen Michael Fallings, he was on MSNBC and a few other news shows talking about the first round of deferred resignation. So, Michael, welcome. Thank you for being with us today.
Oh, thank you, Doug, for having me.
So, Michael, I know you're very familiar with this topic, and we would like to know, what are you telling your clients when they come and say, hey, I got this email about the deferred resignation? What are you telling clients about this?
Well, I think it's very situational. So it is, looking at your particular employment situation to determine whether to accept it or not. First, I think you got to consider, whether or not you're pending any kind of performance review or bad performance evaluation or pending proposed disciplinary action. Because if you are, that could be an incentive to take it, given that the government, may take action against you. I think, employees that are, working far away or have been working remotely far away from their duty station, they've been ordered to return to work, maybe that's still pending, or there's been issues about commuting to the workplace since they've been returning to work. Maybe that's an incentive to take it. You mentioned the voluntary early retirement authority. That's something that employees could consider as well, that we're considering retiring or considering saying, hey, I don't know if I want to stay at this, government place anymore, given everything that's going on. So it is very particular for each employee situation. But I mean, it's still I think with even the last one and this one, it's still kind of a nerve-wracking thing, given it's still a short time frame for these employees to consider all of their options and determine what to do. I know some employees that have always wanted to work for the federal government. They wanted to work for years, but they're scared because of the rifts that are happening, and just the sentiment that the government, is going to reduce the force either way. So it is, these employees do need to make their own personal decisions, consider, what is best for themselves, and, what's best for their sustained employment.
Now, it's my understanding that the first round that was being done by OPM, and there were a lot of legal challenges because OPM was doing it. This new round is being done by the different agencies, and it's my understanding that, for example, Department of Homeland Security, they have until I believe it's April 14th to reply. Secretary Collins is being more generous, giving us till the end of April. Now, there was some talk last time. There was some kind of fine print in the last offer that people could be recalled to work. So if you said, I'd like the deferred resignation program, I want to stop working, get paid till September 30th, there was some concern that people could be brought back to work. And do you know anything about that with respect to this renewed offer?
I think the language that the agencies have used on this offer is similar. That is the employees are supposed to be on admin leave basically until that September 30th date, but the government really does, still control, whether or not, what the employee does during that time frame. Meaning that I know the government has said that, well, the employee can only work, if they decide to work anywhere else, they have to work in these, specific areas. They can't work anywhere that conflicts with, this agency work. As far as being returned to work, I know the government agencies have said that up to a certain date that employees could be returned to work, but I believe the language has been similar to last time, that after that date, then those employees will be on administrative leave. There have been, I think, other differences as far as the agencies being more control of this deferred resignation program. We've seen some agencies not include in the agreement that the employees have to waive all claims. We've seen, but that's been varied through each agency. So I think the employees by the Department of Veterans Affairs or any other agency employees really need to look at those agreements and understand what they're agreeing to before they sign.
Well, you brought up something that's interesting. And so, for example, say somebody has a pending EEO claim, and it could be a meritorious claim, and they take the deferred resignation. There is something about waiving all other grievances, claims, things like that. Would that all of a sudden, that EEO complaint, would that disappear, or would that still be an active complaint?
Technically, it should disappear. The language specifically says that the employee is waiving any and all claims pertaining to this agreement and their employment with the agency. So that would include any pending EEO complaint or any pending grievance or MSPB appeal, because that complaint is against the government agency. Now, the enforcement of that I've seen varied across agencies in my practice. I've seen some employees that have signed the agreement, but their complaints are still continuing. But technically, by the language in the agreement, they are withdrawing all of their claims, which the first deferred resignation was something that a lot of employment lawyers really took to advise their clients, because that language wasn't included until after that first email was sent, and it was really buried into the agreements. It was like paragraph 11 or 12 in most agreements. Most times when you see a severance agreement or any agreement withdrawing claims, it's paragraph 1, and it's almost always in bold letters, that just to make it clear what the employee is agreeing to. So it almost seemed like it was thrown in there last time. Again, this time around, it hasn't, as far as various agencies, it hasn't been across the board that's been included, but I believe that's the intent by the government, is to make sure that they're not being, sued after, an employee signs. I think that still raises issues, though, because that raises questions about the employee trying to enforce the agreement. There were significant questions about, well, what if there happens to be an issue regarding the employee's pay or benefits that the employee doesn't believe they were paid correctly? Well, how do they try to enforce that issue during the administrative leave period? I believe OPM last time came out and said, well, you still have a right, for, back pay and whatnot, but it still remained unclear, given they are waiving their rights, who or how they enforce that agreement. So I think that language is still unclear in the agreements it's in, on how employees will be able to enforce the agreements should there be any issues.
And also, just to be clear, we had a couple of questions before this from some of our members. And the Deferred Resignation Program, if it's offered to you, it's not like a VERA. There's no requirement that you have either 20 years of service or on an age limit. I think it's 20 years of service and you're age 50, or 25 years of service at any age. There's no requirement. If you're offered this, you can elect to take it regardless of your age and your service computation date.
Correct. My understanding is it's offered to all employees, for the agencies that are offering it. I know last time some agencies were excluded, the military was excluded, but for those agencies that are offering it, it's offered to all employees regardless of years of service, even probationary employees. If there are still any probationary employees there, they've been offered this as well.
And you touched on something, and it really caught my attention, and it's going to come up, I know. So say there's an employee who has a rating of record of unacceptable performance and they're on a performance improvement plan, or there's somebody with proposed discipline, a proposed suspension, and they say, you know what, I think I'll take this. Now, are they going to be allowed to take this offer? Or are they going to be excluded somehow?
That's a great question, because I've seen that happen, and I would say it again has not been across the board as far as how agencies have dealt with it. I've seen some agencies reject that employee attempting to take the deferred resignation. In my opinion, it's being offered, and if you're still in the window of allowed to accept it, you should be able to accept it without regard to the proposed discipline, and that should prevent the proposed discipline or any discipline being on your file that's not already in your file. So that's why we've advised employees that are in those situations to strongly consider that. Always also considering the sufficiency of the disciplinary action, the performance action against the employee. But still, if those employers are facing those circumstances, that is something to consider. However, we have seen at times some agencies try to prevent those employees from accepting the deferred resignation. I don't believe, in my opinion, that's allowable, given that this is a government offer.
And I would think they just want people to leave. If you're having some discipline problems, it's something that, they want us all to leave. It seems like the more, the merrier who leave, who exit. And I don't know if we touched on this, because I know we were talking before we press record, but if you get the email, if you reply to the email, I would like to take the offer. Now, is that an acceptance of the offer? Because, and then I believe they send you the document to sign. Now, before you sign that, but after you send the email saying, yes, I'd like to take it, can the employee rescind that acceptance, or is that it as soon as they send the email?
So in my opinion, the agreement is not enforced until there is a signature on that agreement. The reply to an email is not, in fact, creating any kind of contract. But again, I've seen situations differ on how this is enforced. So I've seen employees that have accepted, say, I accept, and then later decide, after they learn the full circumstances, specifically they're withdrawing their claims, that, well, I don't want to actually sign the agreement. And I've seen in circumstances those employees still be allowed to work for the agency. I have clients that have gone through that situation. They're still working for the agency. But I've seen also some of my clients that have tried to retract their resignation that they accepted, and the government say, no, you must resign. In my view, I would argue that's a constructive discharge when an employee attempts to retract the resignation. after they've emailed saying they will resign, but they haven't signed any agreement. There is law to say that an employee controls their own resignation. So if they email saying they resign, then they've resigned. But in my opinion, with those employees that emailed to say they resign were doing so based on incomplete information, and they subsequently learned information, just referencing the last deferred resignation period. They subsequently learned the information through the agreement they were given and decided, well, this is not something that is beneficial to me, and they made a different determination. So in my opinion, that first response to an email saying they've accepted a resignation wasn't really was doing so based on incomplete information, and they are permitted to kind of retract that resignation. And if they're still forced to resign, I think those employees may have a claim. I think those situations differ. And I think it depends on the circumstances. But I think overall, to answer your question, it's varied. It depends on the situation. But in my legal opinion, I think the resignation isn't deemed a true resignation until you've signed that agreement.
Well, there's a lot to consider, and I think a lot of people don't know what the rules are, what the laws are, and there's a lot of chaos. And we're so grateful to have you here with us today to explain all this, because the lack of communication we're getting from the department, it's very difficult for employees to make decisions. And AFGE is here, the union is here to try to provide those answers. And when we have people like you sharing your insights and your knowledge, it's very helpful for us. And Michael, I want to thank you for being here today. And we really appreciate you. We appreciate Mike Murray and your marketing department for setting this up. And thank you very much.
Thank you so much. I'm so glad to speak to the AFGE employees. So I'm so happy to be here, and thank you for having me.
Thank you, Michael. Take care. Bye-bye. Just recap, we have until April 30th to make this decision. It's another 2.5 weeks. If you decide now or you decide a week from now, it doesn't make a difference. What I would caution people, plan this out. Try to make a well-informed decision for you and your family, and don't rush into this. I understand it is very demoralizing to be in the federal government right now. I saw Secretary Collins' Senate confirmation hearing. He talked about unleashing the power of this wonderful workforce. And we've been here, it's only been a few months, and it's insults been hurled. We're the deep state, we're the radical left, we're the swamp. And really what we are is we are dedicated federal employees just trying to do a job, trying to serve veterans. And, a lot of us know each other. We know what the work we go through. And this is not about getting rid of fraud, waste, and abuse. We all want to get rid of fraud, waste, and abuse. Most federal employees are like, yeah, we could be better here or better there. And there's other ways to do that. Bill Clinton cut 400,000 federal jobs. He did it over a 7-year period. A lot of it was buyouts. It was attrition. And it was kind of done with a scalpel, with surgical precision. And this is being done very differently. We had Elon Musk on stage with a chainsaw, that metaphor. And, I understand many people are like, I've had enough. And I know this is going to be a highly successful round of deferred resignations for the agency, because I think between February and today, there's been a lot going on. And, this may be the right decision for some people. It gives you 5 months if you want to plan, to try to secure another job or whatever you need to do for yourself and your family. But for many people, just remember, as soon as September 30th comes around, you don't have a paycheck anymore. And that's going to be a reality that you face if you don't have another job. And I'm assuming the DC market's going to be flooded with people looking for jobs. And it's not like what it was with unemployment rates at 4%. So it's a tough decision. Where AFGE Local 17 is here for you. We got a lot of questions. We sent out a survey. Now, we didn't get to a lot of them today, but we're going to put this on our website. We're going to put the questions and the answers with this video. And we want to thank you for being a loyal member. And if you haven't already switched to e-dues, please do so. The department ended their payroll dues deduction. I think we have most of the people on e-dues. We're one of the few locals that have gotten that far. But anyways, I want to thank everybody for your loyal membership. And we've been able to do amazing things because we have the support of our members. So thank you very much.